Hello, everybody. I'm John Fabricius, Executive Director of Arizonans for Transparency and Accountability in Corrections, and this is the AZ Prison Report. So we've got a really good one this week. We have got the much anticipated remedial order that was issued by United States District Court Judge Roslyn Silver in relation to the class action lawsuit that was filed by the men and women held in the custody of the Department of Corrections. And this was certified as a class, so it became a class action lawsuit. And it affects, there's currently 33,600 plus or minus men, women, and even some minors in the Department of Corrections presently. And this holding affects everybody that's held in a state facility. It does not include those that are held in any of the private facilities while they're in the private facilities, because those private facilities have their own medical health care that was not the subject of this lawsuit. But if someone is at a state facility, then they would be a class member of this lawsuit. When they're transferred to a private facility and held there for whatever period of time that they are held there for, they are then outside the class because they're at that facility, the private facility. But once they are transferred back into a state facility, once again, they become a member of the class subject to the holdings in this remedial order. Before we get going into this story, I want to make sure to ask you to please like, share, and most importantly, subscribe to this channel. This gives us the opportunity to continue to reach out to you through YouTube and keep you informed of exactly what's going on in our Arizona prisons and in our work at Arizonans for Transparency and Accountability in Corrections. So please smash that like button, subscribe to this channel, and share this video. Thank you so much. Now let's get into the story. And so before we get into the actual story of the order, let's talk about all the people that are going to be discussed here in the story. So as you may know, the United States District Judge that ordered the parties to trial and has issued the remedial order and found that the Arizona Department of Corrections did violate the Eighth Amendment rights of all the incarcerated is Judge Roslyn Silver, United States District Court Judge Roslyn Silver. She is a senior judge sitting on the district court. And then the other players that are important here is obviously Governor Katie Hobbs. The Arizona Department of Corrections is an executive agency, meaning that this comes under Katie Hobbs' control. David Shinn was the director of the Department of Corrections. And then David Shinn had two deputy directors that were underneath him. That would be Frank Strada and Joe Prefori. But under the current scenario, what we have is that most of these people have gone, and Shinn has gone. He has left and left the Department of Corrections. We actually don't know where he's going now. Frank Strada is gone. He was appointed director of the Tennessee Department of Corrections. I think they call it director or possibly secretary in Tennessee. And last but not least, it's Joe Prefori is gone. He's gone as of last Wednesday, I believe, and he has been appointed secretary or director of the Arkansas Department of Corrections. So David Shinn is just gone and is probably going to land in some job somewhere, running a prison system or something to do administratively. And then both Frank Strada and Joe Prefori have been appointed as directors of the Tennessee and Arkansas Department of Corrections, respectively. So that also brings up a level of complexity as well, because as we've talked about before in an earlier video, the Arizona Department of Corrections is at its lowest level of staffing in its history. It's below critical. It hit critical a while ago. It's well below critical staffing. There's more than 1,900 open vacancies right now in the Department of Corrections. That's a 20% vacancy rate, I think, compared in contrast to what their personnel rate is right now. Something along those lines. It's not good. That's probably not even the correct number. That's just me doing that off the top of my head. So at the same time that we have the lowest staffing levels in the Arizona Department of Corrections, we also don't have an active administration there. The director's gone. The 2 deputy directors are gone. I have to check this, but I believe that the individual that was running the Inspector General's office inside the ADC is now the current director. I believe that that's correct. And in an interim fashion. And of course, we are awaiting Governor Hobbs from appointing a new director. However, there has been many organizations such as ATAC and many other ones that have reached out to Governor Hobbs and said, please do not just hire another director. Don't set that person up for failure. Let's conduct a full audit of the Arizona Department of Corrections. Let's shine some sunlight into this place. Let's see what we're actually working with, because it is clearly beyond critical, systemically failing in so many areas that to just bring in somebody now to replace Director Shinn, it would be not setting that person up for success, in my opinion. And so the full audit does need to be conducted. Moreover, we don't want a director that's going to come in, to be an authoritarian and or be, a Pollyanna, either, because both of those will demonstrably result in negative outcomes for those that are actually incarcerated and probably and the line level staff as well. So it's better to do this. It's the old adage from construction, right? Let's measure twice. Actually, let's measure 3 times. Let's measure this thing before we start cutting the wood, because lives are at stake here. This is really important. All right. So Governor Katie Hobbs has to, at the same time she is ensuring the implementation of Judge Silver's order in the Department of Corrections, she's at the same time having to refill an administration in the Department of Corrections. This is a lot. This is a big lift, and there's a lot of other things going on in the Department of Corrections that still need a lot of attention. So this is a very, very big deal. All right, let's jump into the order. All right. So here is the remedial order that was issued by Judge Silver. This was issued on January 9th, last Friday, from the time I'm taping this video. And so let's go through it. I'm not going to go through the entire order. It's 69 pages. I wouldn't want to do that to myself and or you. But I do want to hit some highlights, and there's some highlights in this first section. So there's one thing that I want to talk about here too, and it's something that I think a lot of people don't understand unless you've looked at prison litigation as inside federal courts. Unless you're involved in that some way, you're probably unaware of some particular laws that that the courts are required to abide by when they do these type of orders. This is an injunctive order. So let's get into it, and I'm going to make a point here in just a little bit. All right. So this order includes the requirements of the planned injunction. The court is going to be issuing an injunction enjoining the Arizona Department of Corrections. The parties and NAFCARE. NAFCARE is the current healthcare provider, the current private healthcare provider that has been employed by the Arizona Department of Corrections to provide medical services. This we will be doing an additional video on. This was, by all accounts, a crazy contract that took the cost, I almost doubled it. I'll have to go back and check that. But we used to pay something like $17 a day per incarcerated person in the Department of Corrections for healthcare. And I think that amount per diem went up to something in the $30 range. I'll have to check. The parties in NAFCARE will be allowed 30 days to file written objections. So the parties do have the opportunity to file a written objection, as well as time to file responses to those objections. The terms set forth in the planned injunction are the product of extensive work by the court and the experts that the court had hired. The experts worked with all counsel and personnel at the Arizona Department of Corrections. Therefore, the parties should not anticipate significant changes will be made absent compelling reasons. The judge goes into saying this a couple of times in this order. Basically, what it's very clear here, and the judge says this relatively explicitly, is that the judge is very fed up with the Arizona Department of Corrections continued what we call, in my opinion, were dilatory acts, meaning that they were acts in order to impede or lengthen the time of this lawsuit would be going on. Going into the settlement agreement or requesting from the Department of Corrections, requesting the settlement agreement, and then subsequently breaking nearly every term of the agreement repeatedly, not acting in faith, which rendered contempt fines of $1.4 million and $1.1 million collectively from two different judges at two different times in these proceedings. And the court said the last time that she sanctioned them for the $1.1 million contempt sanction, she told the plaintiff class that she could have done that for $25 million because the Arizona Department of Corrections repeatedly were in contempt of court and repeatedly in violation of their own settlement agreement. It was absolute madness how non-compliant the Arizona Department of Corrections was during these proceedings. And remember, this court case was filed in 2010 or 11. This thing was over a decade old. This is a long case, and the settlement agreement was reached in 2014. So there had been 6 or 7 years of the settlement agreement by the time the court had made the decision to withdraw the settlement agreement and compel the parties to go to trial. All right. The parties are reminded this injunction must remedy the serious constitutional violations found at trial. And that was the order that the court found that the constitutional rights, the Eighth Amendment constitutional rights of the men, women, and minor children held as adults in the Arizona Department of Corrections at the state facilities were systemically violated by the Arizona Department of Corrections in 3 general areas: the provision of medical care, the provision of mental health care, and the overuse of solitary confinement. Okay, so any objection based on the belief that a proposed provision goes beyond the scope of facts proven at trial must be supported by argument establishing that provision has no relation to the claims and facts given at trial. That is, the court has already attempted to ensure each provision of the proposed injunction is directly linked to a constitutional violation proven at trial. The court's experts made additional recommendations with the court, which the court did not include because they could not be specifically supported by what was proven at trial. Therefore, the court is likely to overrule any objections asserting certain provisions cannot be linked to the facts proven at trial. For any provision where the parties have an objection, they must set forth the basis for the objection and propose an alternative solution using the same general framework as set forth in the injunction. All right. And then she gives an example and requires them to confer. What the judge is saying here is that the judge went out of the way to get experts that both sides could work with. Both sides were given the opportunity to suggest and then object to the other side's suggested experts. there was an agreement between the parties to certain experts. Those experts conducted investigation and recommendations and produced recommendations to the court regarding remediation and regarding this injunction. The court looked at those suggestions and then rejected any that could not be any of those recommendations by the court appointee specialists that were not directly related to the facts proven at trial. So if there was basically, that's mission creep. Basically, if these, the court is saying that anything that was beyond the scope of what was proven at trial that has come back as something that needs to be fixed in the Arizona Department of Corrections, she's not including that. And so because she's gone through that process, because these things are directly tethered to specific violations of constitutional violations found at trial, she's saying that there's very little chance that she's going to sustain any objections to this, and that any arguments to that must be supported and must have an alternative remedy attached to them as well. All right, let's see where we are here. Okay, so let's get down here. So let's go to the draft injunction. All right, so on June, this is basically the summary of what we need to talk about in this order, right? So on June 30th, 2022, the court issued its findings of fact and conclusions of law, document 4335. In that order, the court required the parties nominate proposed experts to assist the court with crafting an injunction that complies with the statutory limitations on injunctions addressing prison operations. That's what I was just referring to. The parties got to select their experts. Or nominate their experts. The parties subsequently nominated their preferred experts. In their list, defendants named Dr. Mark Stern. Defendants in writing informed the court that Dr. Stern's dedication to design, management, and operation of health services and correction settings would provide this court and the parties with valuable guidance in crafting an injunction regarding the provision of medical care at the Arizona Department of Corrections. After reviewing the parties' list, the court solicited additional briefings. In that additional briefing, plaintiffs made no objection to the appointment of Dr. Stern. All right. So on August 4, 2022, the court held a hearing with the parties and Dr. Stern. During that hearing, the court noted that Dr. Stern's past work in this case made him experienced and therefore an attractive expert to help with crafting an injunction. Dr. Stern stated he could address medical care aspects of the planned injunction, but he would need additional assistance on the topics of mental health care and conditions imposed on the subclass, meaning I believe that's referring to the solitary confinement use, because they don't, it's not everybody clearly in the Arizona Department of Corrections is being put in solitary confinement, so that would be a subclass. Or a section of subclass. And I believe that's what that's referring to. Dr. Stern stated he had individuals in mind who may be able to assist him on those topics. After finding Dr. Stern was an appropriate expert, the court discussed with Dr. Stern and the parties the type of communications the court experts could have with the court and the parties. Both sides agreed the experts could have ex parte communications with defendants, defense counsel, plaintiff's counsel, and the court. Accordingly, the court held the experts could have ex parte conversations as they are deemed appropriate. The court stated it would keep general notes regarding these contents of these communications with these experts. Basically, what that means is an ex parte communication is any time a party or somebody is inside of a case. I'm not a lawyer, so I apologize to any attorneys that are watching this where I fumble this up. But in general terms, please look this up. But ex parte communications means I believe it's a communication with the court without the other side there, right? So fundamental fairness, these type of things in a court proceeding says, one party can't go and have private conversations with the court in generally. And so an ex parte communication is when that happens. Now, there are certain conditions when that should be allowed, and that's what the court is referencing here, is that the court's experts needed to have conversations with the court to get this work done. And so both parties I believe that's what this is saying, is agreed to allow the experts to have those ex parte communications. And the court would keep those general notes. Now, it's really important to note that this was Dr. Stern, as it says here, was a defense-appointed expert, or was what the defense wanted, right? That means that's what the ADCRR wanted. They got their expert. And yeah, but pretty sure that that's correct. Finding fact that nominated parties subsequently nominated for an experts. List defendants nominated Dr. Mark Stern, right? So this was Dr. Mark Stern did come from the defendant's side. Okay. The day after the hearing, the court formally appointed Dr. Stern, and shortly thereafter, the court appointed 2 additional experts to assist Dr. Stern, to which the parties had no objection. Those 3 experts then began crafting recommendations for the final injunction. In doing so, the experts have had extensive back and forth communications with individuals who had relevant information. Thus, Dr. Stern and Dr. Bart, I'm going to mess that up and I apologize, Dr. Abplanalp. I'm going to go with Abplanalp, and I'm very sorry if I'm messing that up. Abplanalp. Spoke with plaintiffs' trial experts, plaintiffs' counsel, defendants' ADC defendants, and the ADCRR personnel, Centurion personnel, and NAF care personnel. So what they're saying here is Dr. Stern, Dr. Abplanalp, excuse me on that. We'll call him Dr. Bart, just to make that. So Dr. Bart, Dr. Stern, Dr. Bart, spoke with the plaintiff's trial experts, plaintiff's counsel, defendants, ADCR personnel, Centurion personnel, and NAF care personnel. John McGrath spoke with some of the same individuals, but he also spoke with wardens, deputy wardens, and other custody staff. Mr. McGrath visited some of the facilities to gain a better understanding of possible solutions to the flaws identified by the court. The experts have also explained some of their recommendation changes to the court. Altogether, the court-appointed experts have spent close to 500 hours investigating and identifying the appropriate solutions for the unconstitutional findings outlined in the court's findings of fact. So, basically, the primary expert and the 2 supportive experts go and conduct a number of investigations and interviews and conversations with relevant people, and spend 500 hours doing so to come up with their recommendations, which also caused them to modify some of the recommendations that they had made earlier. The back and forth between the parties and the court's experts included discussions regarding specific recommendations the experts might propose, and the experts have incorporated some recommendations made by the parties or their agents, and the experts may not have otherwise included. I think I messed that sentence up. And the experts have incorporated some recommendations made by the parties or their agents that the experts may not have otherwise included. In other words, the experts have thoroughly made genuine efforts to assess the possible solutions to the unconstitutional conditions, and they paid particular attention to the solutions proposed by the defendants and their agents. Over the approximately 4-month period of the experts' work, the parties or their representatives had a simple opportunity to explain to the experts why particular solutions were not feasible, or why the experts should recommend some solutions over others. Accordingly, this detailed injunction contains little, if any, requirements that surprise defendants. I think you should be picking up something here. The court used the Department of Corrections expert. The court is going out of the way to point out that the defendants, the Arizona Department of Corrections, have got their expert. They had multiple 500 hours worth of conversations with those experts, legitimate investigations into what would work, working with the defendants, the Arizona Department of Corrections. The court is going out of its way here, in my opinion, to signal to the Arizona Department of Corrections and to signal, I think, to higher courts, courts of appeal, the United States Supreme Court, that it was going out of its way to accommodate the Arizona Department of Corrections here. And I think that that's what's been going on this entire time in this matter. And there's a reason for that, and we'll get to that reason for it in a second. And it's not necessarily because the judge has affinity for the Arizona Department of Corrections. It's a legal reason, and we'll get to that in just a second. The court's findings of facts and conclusions of law established defendants' basic model and staffing decisions for the provision of medical and mental health care create an unconstitutional substantial risk of serious harm to plaintiffs. That's a big statement. Let's read it again. The court's findings of fact and conclusions of law. This was the order that was, or this was the finding that was issued in June of this year. Okay, this was when the court found that the Arizona Department of Corrections violates the Eighth Amendment rights of those that are incarcerated. The court's findings of facts and conclusions of law established the basic model and staffing decisions for the provision of medical and mental health care create an unconstitutional substantial risk of serious harm to plaintiffs. Therefore, the changes necessary to alleviate that risk will be substantial. Similarly, the insufficient staffing and a wide variety of conditions of confinement combine to create an unconstitutional substantial risk of serious harm to subclass members. Those, again, the changes necessary to alleviate the risk of harm to the subclass will be substantial. Given the extent of the existing dysfunction in the defendant's operations, the court will provide significant detail regarding medical care, mental health care, and conditions imposed on the subclass to remedy the substantial constitutional violations. Let's go on a little bit further, then I'm going to come back and comment on this. The unusual scope of this injunction. Let's really peg that in our mind. The unusual scope of this injunction is informed by defendants' actions throughout this case. That's a chill, shivering signal to send to the defendants, for sure. That would be defendants here is the Arizona Department of Corrections. The unusual scope of this injunction is formed by the defendants' actions throughout this case. Despite their agreement and promise to the court to do otherwise, defendants have fought every aspect of this case at every turn. Defendants entered into a settlement agreement where they claimed they would improve the care provided to prisoners and improve the conditions of confinement for the subclass. Defendants almost immediately failed to perform those obligations and continued in that failure. Instead of acknowledging their failures, defendants kept inaccurate records and misinterpreted the settlement requirements to their advantage. We're going to go back on this. During trial, defendants presented arguments and witnesses that were manifestly unpersuasive. And on the same aspects, defendants presented no meaningful defense. For example, defendants did not present any expert testimony that the conditions imposed on the subclass were appropriate. Most importantly, trial established defendants still had not made any serious efforts to remedy the flaws highlighted by this litigation. Given this history, the court cannot impose an injunction that is even minutely ambiguous because defendants have proven they will exploit any ambiguity to the maximum extent possible. All right. Now, with all due respect to all of the attorneys out there that look at these type of things all the time, look at decisions, I'm sure you've seen admonitions by courts to bureaucrats in the executive branch before that probably exceed this. I am unaware of one. I'm unaware of a court that has gone so far to accommodate an administrative agency, the Department of Corrections in this case, only to have that department basically spit in the face of the court for giving them that leeway, and then the court calling them on it. This court has made no, has not buried the lead when it comes to calling out the Department of Corrections in her holdings and the director, for sure. So what does this mean? Okay. Let me continue first. Despite defendants' unsatisfactory past behavior, the court appreciates that the injunction is required to be narrowly drawn, extend no further than is necessary to correct defendants' ongoing violations of plaintiffs' constitutional rights, and be the least intrusive means necessary to correct to prevent the violations. 18 U.S.C. Section 3626, subsections A1A. All right. In addition, the injunction must describe in reasonable detail what defendants must do and must be specific and determined. What defendants must do and must be specific and definite to allow for accurate monitoring and, if necessary, enforcement. And that comes out of Federal Rule 65, Rules of Civil Procedure Rule 65, which is on injunctions. United States, and that's supporting case law in the Ninth Circuit. Okay, so let's talk about this. This is the section that I was talking about. I want to talk about this footnote right here. As expressed, this is footnote coming off of this sentence right here. Given the extent of the existing dysfunction in defendants' operations, the court will provide significant detail regarding medical care, mental health care, and conditions imposed on the subclass to remedy the substantial constitutional violations. Footnote, as expressed multiple times throughout the almost 10 years this case has been pending, the court has no interest in micromanaging defendants' operations. At the hearing on August 4, 2022, the court stated, "I am not, and I have said this a number of times, I don't know how many times, but the court is not in a position and never should be in a position of running prisons. That's not my job." But she's having to do that job because of, yep, you guessed it, the extent of the existing dysfunction in the defendant's operations in the Department of Corrections, and so thusly requiring the court to provide this detail. So all of this section, all of this deference that we have been talking about, in my opinion, all of this deference, choosing the expert provided by the defendants, allowing them, going through all of this exposition, talking about how far the defendant's own experts went in investigating the issues inside the Department of Corrections. Deference again. The court is saying all that because, and setting this all up because of that law right there, 18 U.S.C. 3626. And this is part of the Prison Litigation Reform Act that was passed in 1996. So let's take a quick aside and talk about the Prison Litigation Reform Act. So the Prison Litigation Reform Act set forth a number of laws. This was a United States Congress passed this law in 1996, and it was to stop what was being asserted as the vexatious or to stop prisoners from filing frivolous lawsuits. It wasn't. If research has been done, there were not any higher number of frivolous lawsuits coming out of prisoners as there were anybody else. This was just an attack on the rights of inmates and prisoners to file for conditions of confinement complaints in federal court, alleging civil rights violations. And this was a big part of the whole being tough on crime move in the 80s and 90s. The Prison Litigation Reform Act comes out the same year as the Anti-Terrorism and Effective Death Penalty Act, the ADPA, which had horrible impact on criminal appeals in federal courts. and the Prison Litigation Reform Act. And what the Prison Litigation Reform Act did was it put a number of requirements on anybody that's incarcerated in a state or federal facility on what they are required to do before they can file a lawsuit in the United States District Court alleging conditions of confinement or other issues related to their incarceration. This is where the exhaustion of administrative remedies, or many of you might know the grievance process, became required. The requirement is right here. That's what came in this law. It also, the Prison Litigation Reform Act, also limited filing fees. All the courts have an ability for poor people to be able to file and have a deferral and or waiver of filing fees. The filing fee for a civil rights action in the United States District Court, I think, is $350. It might have gone up this year. It's $350 to file that. That's an enormous amount of money when you make 10 cents an hour. And so it put the filing fees on there. It made them mandatory for inmates, whereas free people could still get a deferral, but inmates can't. They have to pay the filing fees. It set forth a structure that it would collect it at 20% of what they were making. This was just to make it really difficult and really onerous for somebody to get there. The grievance process made it extremely difficult and onerous and put a bunch of landmines on the way to filing it, because what the grievance process did was, if you didn't dot every I and cross every T and follow the administrative remedy process that the state provided exactly, then once you would get to court, you would file your case, you would have to pay that $350, and then your case would get immediately thrown out for failure to exhaust administrative remedies. That happens all day, every day. And that's why grievances are so important, because you have to have your grievances done and exhausted completely through all the appeals, or once you get here, they'll charge you $350 just to get your case thrown out. It also put a physical injury requirement anytime that there was a claim for any type of mental or emotional damages on that. This was also parroted in many states. Arizona has laws parroting this, related to civil actions in state court against departments of corrections. But another part of this also was this 18 U.S.C. United States Code section 3626, appropriate remedies with respect to prison conditions. So this was another thing where the United States Congress told the courts, what you can do is not this big, it's this big, when it's anything related to providing an injunction, enjoining a prison, a state or federal facility. We can't put them under, long-term injunctions anymore. It has to be this. And so this is what the court was citing specifically. It says that any prospective relief, an injunction is a type of prospective relief, prospective relief in any civil action with respect to prison conditions shall extend no further than is necessary to correct the violation of the federal right of a particular plaintiff or plaintiffs. The court shall not grant or approve any prospective relief unless the court finds that such relief is narrowly drawn, extends no further than necessary to correct the violation of the federal right, and is the least intrusive means necessary to correct the violation of the federal right. The court shall give substantial weight to any adverse impact on public safety and the operation of the criminal justice system caused by the relief. So what this means is, this is the Congress telling the courts what you can do in these cases where you are going to issue an injunction. Is you have to make sure that that injunction is the most narrow, specific, and least intrusive to the operations of the Department of Correction as it will. Or there's another court will overturn it on appeal. And the body of law, the jurisprudence on that is, there's tons of them, right? Where the court overturned earlier decisions that were outside the scope of what the court determines was the most narrow, least intrusive means on remedying the solution. In Arizona, we have a famous case, and actually this wasn't necessarily because of the PLRA, but it was United States Supreme Court in a matter called Lewis v. Casey, which was a case that was also settled in 1996, where Arizona inmates had sued the Department of Corrections because of the inadequate law libraries that were provided to the incarcerated. And back then, we had law libraries in the Department of Corrections. We had full law libraries. All of the books on state and federal could be there. You could research case law. You could research all that stuff. You could do a full, there was a full law library in every prison in Arizona, with the exception of some smaller ones, and they had to share them. But the Arizona Department of Corrections was not upkeeping those decisions. Those books have to be renewed every year because decisions keep coming out from the courts. So it's a subscription model. It's expensive. There's no doubt about it. It's very expensive to operate all those law libraries. Law books are extraordinarily expensive. And so the Arizona inmates sued in 90, it was earlier, like 92 or 93 about that. We won in the United States District Court, much like we've won here. We won, and it caused them to get a special master to go in to look at the conditions of the Arizona Department of Corrections. The District Court did. The special master issued a number of findings. Those findings were, I think, excessive, but in certain, there was certain things in there where the special master, I think, had ordered, what temperature it could be like in a narrow temperature that it had to be in some of these rooms and stuff like that. It was micromanaging for sure. Probably, it sucks being in a hot room. I've been in many hot rooms conducting that, but the issue is, does the federal government through the United States District Court have a right to tell the Arizona Department of Corrections that they have to keep a room at 72 degrees as opposed to 76 degrees or something like that? That's the question. And it gets into a big morass of the law. But regardless, there was a majority of very substantive findings inside the earlier things in Lewis v. Casey that were beneficial, that we did need. But unfortunately, that was appealed by the state. The Ninth Circuit Court of Appeals also upheld the Lewis v. Casey decision, but the United States Supreme Court, in a decision authored by Justice Scalia, overturned those decisions, and that we lost throughout the country. Prisons are no longer. There was a case before that in 72, Bounds versus Smith, that said that prisons had to provide, basically had to provide law libraries. And in Lewis v. Casey in 96, that got primarily overturned. Most major sections of that got overturned. And that's when we lost our law libraries. And and now we don't have any law libraries in the state of Arizona. We have access to basically just statute books, couple of federal books. And the United States, what Justice Scalia said is that the prisons don't have to provide law libraries to you. All they have to do is provide you with confer the capability of your access to the courts. And so the Department of Corrections hired one paralegal to service the entire state, and that's the person that helps you access the court, and you have no access to case law or any real substantive legal research. So the point I'm making about all of that and bringing up Lewis Casey is that although that can seem very onerous, it does have an impact where these decisions have to be narrowly drawn and to remedy those issues. And I don't necessarily agree or disagree. I'm not making that argument. But what I am saying is that that's why the district court here, Judge Silver, is going to this extent to explain all of that stuff, because she understands also the Prison Litigation Reform Act and being appealed and having her decisions overturned. And she's going out of her way to give deference to the prison, to explain the reasons why she's issuing such an order with such detail and such minutiae in it. And she's doing all that, in my opinion, to explain to a reviewing court, if the state decides to appeal this, why she made these extraordinary moves in this matter. So, qualitative and quantitative. That means quality and quantity, right? The extended history of this case mandates a need for the court to impose both quantitative and qualitative measures. Let's go to the footnote. As used here, quantitative refers to measuring only the quantity of certain events or actions. Qualitative, on the other hand, refers to measuring the appropriateness of the events or actions. The stipulation's performance measures were quantitative in that they merely reflected a tabulation of acts or events. The performance measure scores did not require a qualitative inquiry and did not reflect whether any of the acts or events that occurred were medically appropriate under the circumstances. So what is the court saying right there? Basically, what the court's saying is that this injunction that she's putting out, let's step back, that the stipulation, the agreement that the parties reached in 2014, stipulated agreement, the metrics there were quantitative. And so the metrics were not so basically what they were measuring was, did John Fabricius get to see the medical provider as an issue? Was it yes? Okay, checkbox. Not did John get to see the medical provider? Check. And was the care provided of the necessary minimal quality for the issue? Check. So the court's saying all we were doing before was checking whether or not he got seen. We weren't saying if there was anything qualitatively done or there was a quality of care. And so the court here is saying we need to institute both quantitative and qualitative metrics for review. And I think that's incredible. It's absolutely true. Monitoring. Okay, here we go. Unlike the attempts at monitoring under the parties' settlement, the court will appoint its own experts to serve as monitors to evaluate defendants' performance. The court appoints Dr. Mark F. Stern, Dr. Bart, I'm not going to butcher his last name again, I apologize, doctor, and Dr. Laura Strick, and an individual devoted to custody issues. Let's drop down to that footnote. This is necessary to Mr. McGrath's passing. Mr. McGrath was a court-appointed expert here too and passed away during the pendency of these proceedings, I believe. So it's going to be some it's unknown person at this point. Devoted custody issues to assist the court in monitoring defendants' compliance and this order. Dr. Stern may appoint additional appropriately qualified and credentialed staff as needed to assist the aforementioned monitors in their work. Defendants shall provide these monitors and additional staff remote access to the EHR and other electronic records, example EOMS, that are available by remote access and necessarily for monitoring. I think that these are electronic health records. I believe that that's what's standing for. I'm not sure what these acronyms stand for, but my guess is that they are medical, cloud-based medical records that they can access and see all these records electronically. Monitors will generally provide advance notice prior to the visits of facilities. However, they may make unannounced visits as needed. Monitors and their staff may bring into facilities cell phones, computers, tablets, and cameras necessary to conduct monitoring and activities. The monitors and staff will be responsible for securing such equipment and following the rules with regards to these materials. Monitors may record any still or video images within all facilities necessary to document conditions relevant to this order. Monitors will make every effort to avoid including the face of any individual, staff, or prisoner unless it is necessary for the monitoring purposes and the individual agrees. In the event an image includes a face and the image is filled with the court, the face will either be blurred or distort the image. Okay, so this is just protection. They're just trying to get into protection from public records of putting people's faces and identities in these raw documents. Despite the appointment of monitors, much of the monitoring will depend on data collected by the Arizona Department of Corrections, the defendants. Therefore, defendants shall use reasonable judgment in selecting methodologies for monitoring compliance and shall exercise care in the underlying measurements. As parts of Arizona's decisions to outsource prison or health care, defendants must monitor the performance of their healthcare vendor. Monitoring of this injunction will use that pre-existing monitoring apparatus as much as possible, but defendants will also be required to collect monthly data and perform analyses beyond what they are doing now. To do so, defendants will be required to employ sufficient staff to an appropriate level of professional credentials and experience to conduct the monitoring described in this order. For example, physicians will be required to conduct qualitative review of the work of all physicians. Defendants may not delegate such monitoring to the vendor. Example, NAVCare, providing healthcare services to prisoners if there is one. Okay, I think that was self-explanatory. The defendants, basically, the defendants are going to also have to provide monitoring of their private contractor, NAVCare, and they're going to have to do it in a way that is acceptable to the court, and that the Department of Corrections will be required to hire doctors to monitor the qualitative provision of healthcare, the quality of the provision of healthcare, not just whether or not they saw a nurse and then got an aspirin for a compound fracture, but whether or not they actually got their fracture set in surgery. That's what it is. So, and the judge is saying that the Department of Corrections must hire these doctors to monitor their private healthcare provider, contract monitoring. Huge one. Defendants shall monitor all elements of this order on a monthly basis. Monitoring shall be completed and available for inspection by the monitors by the last day of the month following the monitored month. Defendants shall maintain supporting evidence for all of their monitoring results. The court monitors may rely on monitoring conducted by the Department of Corrections and any additional information that the monitors obtain. Such additional information may come from a variety of sources, including, but not limited to, interviews with the class members, interviews with the class members. I think there's supposed to be a comma there. Defendant staff or contractors, complaints from prisoners or others. Let me back up on that. Interviews with class member, defendant staff. I'm a little bit lost on that one. Okay. Or contractors, complaints from prisoners or others on their behalf. Plaintiff's counsel, random or purposive review of healthcare records, direct observation, site visits, review of paper electronic records, and review of video records. So this is the court providing a number of opportunities to get this, to assess this information. In general, where performance can be measured by automated systems, a 100% sample will be required. Unless otherwise noted, where the performance must be measured by review of individual cases, reports, health records, events, etc., defense will sample at least 50 items statewide, chosen in an accurate and reasonable manner. As used here, reasonable means that the minimal sample is drawn from a relevant population at high risk if performance is poor and is drawn from venues roughly in proportion to relevant items at that venue. For example, if half of all the maximum custody prisoners are held at Complex A and half at Complex B, minimal samples regarding maximum custody would be drawn in roughly equal numbers from both Complexes A and Complex B. Samples beyond minimum, however, may be drawn from anywhere. This is the court telling, this level of detail is the court making sure that the Arizona Department of Corrections does not continue to engage in any of the chicanery or obfuscation or impediment that they were engaged in before. The court's telling them exactly what they have to do and how they have to do it and when they have to do it. Basically running the prison. As an additional way to monitor compliance with this order, the court-appointed monitors will create a confidential mechanism for current prisoners, former prisoners, and friends and family prisoners, prisoner staff, contract staff, included the contracted healthcare vendor, and public, to notify the court of problems or complaints of unsafe and unsound healthcare conditions or conditions of confinement. As the monitors deem appropriate, the mechanism may receive submissions by postal mail, email, or phone. Within 2 months of this order, the defendant shall design and implement a mechanism for prisoners to submit communications to the court-appointed monitors. Submissions are solely for the purpose of providing relevant information in the monitors. The monitors will not necessarily investigate a submission or take action on behalf of a prisoner. Monitors may or may not provide a direct response to the submission. Defendant's implementation shall inform prisoners and staff that this confidential mechanism does not replace any existing system by which prisoners or others are expected to inform defendants of problems for which they require resolution, such as the prisoner's grievance system or staff reporting mechanisms. So this here is the court creating and mandating that the Department of Corrections create a confidential reporting system that basically inmates, the prisoners, staff, family, friends, everybody, including the NAFCAR, everybody can have a confidential reporting mechanism to the staff or to the court's monitors. And the Department of Corrections is required to create that. So another good thing. This injunction does not set forth the full extent of the data that must be collected, analyzed, and made available to the court-appointed monitors. Defendants shall cooperate with the monitors in devising all appropriate methods of data collection and data transmission. If unforeseen changes in the conditions or operations render any of the requirements of this order obsolete, unnecessary, or impractical, will be identified by the monitors and recommended to the court for alteration. The parties may petition to the court to modify an annual requirement. Defendants will be allowed a reasonable amount of time to implement any modifications. And then right here, defendants and their agents shall not take any retaliatory actions against anyone who gathers or produces information relative to the defendant's performance under this injunction. So not only did the court create a confidential reporting mechanism for the incarcerated men and women, for their friends, family, and for staff, and for everybody to report on what the DOC is doing, and the court order that nobody can be retaliated against for doing so. Okay, and then plaintiffs monitoring. Plaintiff means the attorneys that have been representing the plaintiff class, means the incarcerated men and women that are the plaintiffs in this case, and they're monitoring. When they're talking about plaintiffs monitoring, we're talking about the attorneys for that. While the court-appointed monitors will be a valuable source of information, plaintiffs and their counsel will still have a primary responsibility for assessing defendants' performance. And if defendants do not perform, plaintiffs will be responsible for seeking additional relief. This will require plaintiffs' counsel to have an ongoing access to class members' medical records and the locations where class members are housed. Plaintiffs and defendants will be required to confer and reach an agreement regarding the extent of a plaintiff's access to information and locations. The parties will be able to file the terms of their agreement to inform their discussion. The court notes plaintiff's counsel shall have access to any information necessary to assess defendant's compliance and with all the terms of this injunction. That access, however, shall not overly hamper defendant's operations. At present, the court will likely order the following: plaintiff's counsel, basically the incarcerated counsel, will have read-only access to class members' electronic health records. Plaintiff's counsel will receive monthly data reports already being produced by defendants, and plaintiffs may demand the gathering of additional data and production of reports as necessary to enforce all terms of this injunction. Plaintiffs' counsel will be able to conduct visits to speak to class members and staff and tour units. Those visits likely will be no less than 20 days, but no more than 40 days per calendar year. Defendants will provide substantive and timely responses in writing to concerns raised by plaintiff's counsel regarding individual treatment of systemic issues. All right, so that's as far as we're going to go into this. The rest of it gets down into minutia. This decision is down below in the notes for you to take a look at and to see. But let's just review on what it is exactly the court has done here. The court has found that the Arizona Department of Corrections systemically violates the Eighth Amendment constitutional rights of every man, woman, and minor held in the minors unit that are in state complexes, the 10 state complexes, and that would be the Yuma complex, the Douglas complex, the Safford complex, the Tucson complex, the Phoenix complex, the Iman complex, the Perryville complex, the Winslow complex, Healy unit, Lewis complex, and I think I said Winslow. So that's all of them, right? Because Florence complex, if the Florence complex is in the process of being shut down. So we've had 10 complexes. Florence is almost is shut down or almost shut down. So those state complexes. Now, your privates, your Eloys, your CACF, your Florence West, Phoenix West, and then, of course, the Marana and Kingman, those facilities are private. This court order does not affect those facilities, but it does affect the state facilities. And so as somebody is transferred or is held in a state facility, this order applies to them. If they're transferred to a private during their time that they're at the private, it does not apply to them. And then once they come back into the state facilities, then this applies to them as well. What the court has done, the court found the violation of the Eighth Amendment rights, and that Eighth Amendment rights violation were related to the provision of health care. It related to the overuse of solitary confinement, and it related to the use to the provision of mental health care. And so the court, after making those findings, has issued an injunction, and this injunction is requiring the Arizona Department of Corrections to take a number of steps, which includes these remediation efforts, allowing the court appointed experts to be able to walk into any facility with golden key access, have private confidential conversations, review all records, and be able to monitor the conditions of confinement and the provision of mental and medical health care to the incarcerated in these state facilities, and provide remedial information to the Department of Corrections and to the court. The plaintiffs class, the attorneys for the plaintiffs require retain monitoring as well. And then the court goes into a number of things, and here, let me take you back over here. The court goes into a number of things for mental and mental health requirements. The court lays out all of these specific items that the Department of Corrections will now have to perform, and the experts, the court's experts, are going to be required to ensure to monitor the provision of these requirements. And so, again, like I said, the order will be linked to down in the bottom of the video here, and you can see exactly all of the things that the court is ordering the Department of Corrections to do. And it's extensive and it's detailed, and it's all about the provision of adequate health care. Now, let's talk about one more thing. What does that mean, adequate health care under the Eighth Amendment to the United States Constitution? Here's something that it's really important, I think many people need to remember, which is your constitutional rights as a United States citizen are your bedrock rights, right? These are the minimal rights that you have that protect you from government oppression and neglect, right? From government oppression. So under the Eighth Amendment to the United States Constitution, the Eighth Amendment says that we can't put people in jail without giving them an opportunity for bail, and you can't put somebody in prison, that you can't send somebody in condition to cruel and unusual conditions. And a court has found here that the Department of Corrections systemically violates that right, and is that the people that are held in the Arizona Department of Corrections are being held in cruel and or unusual conditions, in violation of the rights. But that is a bedrock right. That is the minimum that you have. Every other right that you have or rights and privileges that you have in the United States are on top of those constitutional rights, right? Our founding fathers said that these rights are so fundamental. These are such fundamental rights that they don't need to be in the democratic process. They don't need to be, debated in Congress and voted on by lawmakers. These are fundamental rights. They are constitutional rights. They are bedrock principles and rights that you have as a citizen. So adequate health care under the Eighth Amendment is not wonderful health care. It's not, what you're getting down in Scottsdale or at the Mayo Clinic or something like that. This means that the minimal, it's the minimal health care provision of health care that's necessary to ensure somebody is not, living in wanton misery and pain. And, so it's not a lot. Let's not think that this is a lot. And that's something that we should remove from our minds, thinking that, these people in prisons are getting all this health care. Well, the health care that you're provided out here in the world and what's provided in prisons is oftentimes very different. And out here, you get a lot of testing. There's a financial incentive for them to test and for them to treat you out here. The incentive is reversed in the Department of Corrections, meaning this. Out here, when you go to your doctor is acting in good faith. I don't say that they're not, but if they can get this test and they can get that test and they can get that drug prescribed and they can do this, then that's better, right? So they will order the tests, they will order the drugs, they will order the therapies, they will order these things, right? Because then the insurance then pays the money for those services. So it's treating your health care that is sent to insurance or out of your pocket to pay for. In the Department of Corrections, these contracts for private health care flip that entirely upside down. There, we are paying these companies a per day rate of, I think it's above $30 a day now, for every man, woman, and child in the Department of Corrections. We're paying them up front and giving them all of the money and all the profit up front. And then when somebody that's in the Department of Corrections needs to go get care, they're going to get care. But now the provision of that care is coming out of the pocket of the money that's already been put there by these providers that was given to them by the state. So they reverse the incentivization of treating people. So now it creates profit in the free world to get good medical care. It creates a loss of profit inside the Department of Corrections under these contracts. That's why it's the incentivization model is different. So even if they do get medical care and the court orders and stuff, this is still the basic minimal level care that is found in the community to remedy these situations. So we're not talking about great health care here. We're not talking about gold key health care. We're talking about minimum level, below access level, basically. Care is what we're talking about. So, and in summary too, let's just look again at what the court has actually done here. What the court has done is the thing that we have been arguing here in at Arizona's for Transparency and Accountability in Corrections. What has the court said? We need sunlight, right? We have to have transparency before we can have accountability. There's a reason why it's Arizona's for Transparency and Accountability in Corrections. In order to get that accountability, you first have to have transparency. And in order to create that transparency, you need to have people in there that are objective, that do not have a subjective benefit for them to say one thing or the other, for them to objectively go in there and say, okay, here's a set of rules. Is the Department of Corrections applying these rules equally, fairly, and justly to everybody in here? And that's what the monitors have to do. So, but first, we need people to go in there. So this judge has created basically ombudsmen who are able to go in. This is what those monitors are for the court. They're basically acting as ombudsmen. They're going to go in there. They're going to monitor. They're going to investigate. They're going to research issues. They're going to accept complaints from family, friends, and staff. And they're going to investigate those issues and turn over and create reports and provide objective information to the court. That's the point. So exactly like the legislation that we propose, what we're saying too, the first thing is we need an independent external ombudsman to be able to go in to research, have confidential conversations, and to investigate what's really happening in the Department of Corrections. We need the light, we need the sunlight, we need the transparency. Then we need to have accountability, and the accountability is in what the court sets forth here. The court is ordering the Department of Corrections to hire monitoring staff. They are ordering them to hire medical staff. They are ordering them to ensure that there is sufficient mental health staff. They are ordering them to ensure that there is a prison expert that understands solitary confinement and the excessive use of solitary confinement, and to provide information regarding that issue. And the court is setting forth specific metrics that have to be met for the court to determine that the Department of Corrections is operating under constitutional standards. In our legislation, for our oversight legislation, we're arguing much of the same thing. We also have the the citizen-led legislative oversight, prison oversight committee in our legislation. That's unique in this country. Most of the other systems in the country only have the ombudsman or have some sort of other mechanism, nonprofit mechanism, some other thing. Ours has an amalgamation of best practices. The legislation that we support has the ombudsman to be able to go in there and to do that investigation, get those reports, bring out that information, and shine a light in there. And the second part of our legislation is much like the second part of this court order, which is we have a legislative committee that is put together with actual citizens, directly impacted individuals that were in prison and understand what's going on there. Members of both parties from both chambers, the House and the Senate, a prison expert that's worked like an administrator, a warden, those type of individuals, a doctor, a mental health professional, a member of the Correction Officers Union so that they can be represented and have a voice. All of those are on this panel to receive that information from the ombudsman and turn that into policy ideas and specific laws for the state of Arizona, and to report to the governor, because remember, prisons are an executive agency. They are the governor's agents. So providing that necessary information to the governor as well, so that the governor can have the director implement policy changes to be more consistent with the governor's ideas of how prisons should be run. So we need all of that. Basically, what the court has done here is exactly what we are arguing about in our legislation. It's the only thing that can be done in these situations. Prisons are unique in our system of governance. They're the only thing besides military bases that are closed off entirely to the outside. You do not have any regular egress into these facilities. The public can't just walk into a prison. And so that function means that there's only really two people telling stories about the Department of Corrections. And those two people are adversarial, right? It's the incarcerated and the administrators. And staff many times can't come out and tell these stories because they're constrained by policy. So there's three groups at play in any prison. There's the administration of the prison, there's the incarcerated, and there's the line staff. And the line staff and the incarcerated are the ones that have to deal. Both sides are on both sides of the cell door. They're the ones that have to deal with these bad conditions and all of the ancillary problems that those things create. The administration is usually sitting up in some nice office here downtown Phoenix, 150, 250, 300 miles away from any of these prisons, and they get to make decisions like that, and they don't by fiat, and they don't feel the impact of them. And so But many times this party down here, the staff party, they are constrained from discussing these issues by their employment terms. And we saw Director Shinn come in, and that was one of the first things that he did was clamp down on that, because the whole Lewis Locke debacle that embarrassed Governor Ducey and caused Tequila Chuck to run out the door. The reason that happened was because a staff member, Gabby Contreras, Sergeant, got that footage out and got it to the media. And so they can't have that. And we've had other staff whistleblowers come out talking about the computer system failures in the Department of Corrections, talking about the systemic failure at Lewis Complex and the fact that it's on the brink of collapse. And because we talk about with masks relative to COVID and, again, the Lewis Locke events. The deputy warden over at Lewis that got fired as a whistleblower, and all of it. So of the three parties, that just leaves the administration and the incarcerated to tell these stories. And of course, everybody has been conditioned to always not believe anything an inmate is saying or an incarcerated person is saying. And these administrations, they have their whole public relations teams, and they've got experts up there who professionally go and create these narratives that go out to the public that everything is okie dokie, that they are the only line between chaos, anarchy, and public safety, and that, if we challenge them at all, then we are reducing public safety, when in fact we need to challenge them because they are indeed reducing public safety in our prisons, that they are systemically failing to the point where it's causing the public to be harmed by that, as well as the incarcerated and the staff members in there. And we see that with all the news reports that have come out in the last 3 years, primarily reported on by Jimmy Jenkins at the Arizona Republic. So these things are all, this is the movie, right? If we provide these conditions, if we put a prison together, and then we do the things that we've done here with this prison, where we overpopulate it, we come in with all these high-minded privatization things and put a profit model on all of the services and operations around it, and then we flip the incentive to extract as much profit out of this class of people that is being oppressed under the 13th Amendment slavery doctrine set forth in the United States Constitution, and then we put a profit model on top of them and incarcerate them, and then take away any incentive to rehabilitate and get out of prison earlier, and just basically use them as slave chain gangs for private entities out here in the free world to have free, really cheap labor. Then these things, the exact things that we're seeing, are going to play out. And we've seen it play out in other states. It was all easy to call in advance. And many people did. Just go back and look at the work of Caroline Isaacs at American Friends Service Committee in 2010 and 11 and 12, screaming from the top of her lungs, if we privatize healthcare, we're going to have problems, and it's all a lie. And that's exactly what happened. The Republican legislature did it anyways. They shoved it down the throats. They also privatized food services. They privatized mail and telephone services. They privatized commissary services, and then healthcare services. And that has caused untold damage to the Department of Corrections and resulted in the death of many people, and has resulted in the reincarceration recidivism of many people. And it's been, on balance, a horrible thing that's happened in our state. And it's time to remediate these things. And because our legislature has literally no courage of any conviction whatsoever and continued to kick the can down the road, this is what happened. A class action lawsuit comes out. The court sees these truths that we have been saying, that have been being lied about by this administration, and these facts that have been disbelieved by people because they were coming out of the mouths of the incarcerated. And finally, some people listened and went in and took a look, and turned out that it was exactly what the incarcerated were saying, and much, much, much worse. and that's resulted in this huge, historic lawsuit that's happened here. And we haven't gone into that, but the history of this lawsuit and what's happened in this lawsuit in the era of the Prison Litigation Reform Act is absolutely amazing, remarkable, and novel. And this has been a historic suit. So big things going on in the Department of Corrections. The judge has issued this remedial order requiring the Arizona Department of Corrections to take specific actions. There will be monitoring. There will be a number of metrics that the Department of Corrections will have to meet. There's a new set of monitoring going in on behalf of the court. The plaintiffs retain their monitoring as well, and the Arizona Department of Corrections has now been ordered to comply with a number of provisions of this order. All right. Well, thank you for checking in with us on the AZ Prison Report. Remember, as always, please like, subscribe, and share these videos. We're really trying to build out this audience. We're going to do a couple of different series here about the AZ Prison Report, talking about news from the Arizona Department of Corrections. We're also going to be doing a series about our legislative actions and some other events that we've got coming up. So stay tuned with us. Hit that subscribe button, hit that like button, and share this out with your friends. And we thank you so much for joining us on the AZ Prison Report. Have a wonderful day.